Do you swear the information and testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth, so help you God? You're going to have to answer out loud, so
Yes.
the court reporter can hear
Yeah,
you.
and if you need to,
Here, slide
you
over,
might
slide
want to
over.
switch that microphone around.
Give me that mic.
All right, Ms. Driver, I just want to make sure you understand your rights in regard to whether you testify or not in this case. You have a right to remain silent. You cannot be compelled to testify in this case. That is the fundamental, I guess, threshold that I presume you've talked to your lawyers about, but that is your right.
Yes.
Many issues of whether or not a witness is called to testify or not are up to lawyers. It is what's called trial strategy. Lawyers can make decisions about what evidence to present and what witnesses to call. However, that's not true of your testimony. Nobody can force you to testify, but nobody can tell you you cannot testify. That is also your right. You understand that?
Yes, ma'am.
If you chose to testify, you would take the witness stand, you would be placed under oath, and you would be subject to cross-examination, just like any other witness. You understand that?
Yes.
As I said, the decision about whether or not you testify is yours and nobody else's, but it is a decision you should make only after you've had an opportunity to have a full conversation about that with your attorneys. They are obviously trained in the law and experienced in dealing with juries and in cases of this kind, and so you should have a full discussion with them and pay attention to what their recommendation is as far as whether or not you should testify or remain silent. But again, that is ultimately up to you. That is your choice. If you choose not to testify, the jury would be instructed that they could not consider that as any evidence that you are guilty. A little wrinkle in this case is that it is your burden to show the jury that you are not guilty but mentally ill, not guilty by reason of insanity or guilty but mentally ill. That is your burden to show by what's called a preponderance of the evidence. You understand that?
Yes.
So the decision about whether or not you testify should also be made in consideration of that. Generally, defendants are under no burden of proof. They don't have to prove anything. It's all on the state to prove guilt by evidence beyond a reasonable doubt. But there is a distinction, a difference in your case with this not guilty by reason of insanity defense. You understand that?
Yes.
Do you feel like you've had enough time to talk to your attorneys about your decision?
Yes.
Do y'all intend to have any further conversations about that? Do you feel like you've adequately discussed it with your client?
Yeah.
Yes, we're fine.
Okay. So I'm sorry, I don't remember which one of you stated. Mr. Kessler, I think, stated that you wanted to exercise your right to remain silent. You didn't intend to testify. Is that right?
Yes.
All right. You're not bound by that at this point, and until your attorneys rest your case, you still have the opportunity to change your mind and testify if you want to. You understand that?
I do.
Okay. Thank you. You can be seated. Do you have any additional evidence that you intend to present, Ms. Trethaway?
No, I think we're ready to rest.
Okay. So you'll do that in the morning in front of the jury. As far as I know, we will have Dr. Zom available in the morning. At this point, does either side anticipate presenting any rebuttal?
We have some brief rebuttal, like to present that prior to Dr. Solom's testimony. I guess the statute's kind of silent about rebuttal factually to other things. We'll do it whenever the court thinks is appropriate.
Well, I guess at this point, since I have requested that Dr. Zom be here tomorrow morning, I'd like to go ahead and get her up and down, and then if there's any rebuttal, or rebuttal, then I'll allow you to do it at that time.
Understood. We have very brief rebuttal.
I do not have a final draft of the jury charge, but and you know, y'all correct me if I'm misspeaking, but it looks like there are a good many requests that are sort of in an abundance of caution, we'll ask for this. The request about lesser included offenses.
We were actually planning on talking about those tonight, Judge, to see what we can be requested based on the evidence presented. For the record, when you had requested our requested charge, we emailed them to you, but apparently we never actually filed them, so we've just filed the ones that we had emailed you officially right now.
Okay.
I do have a few extras that I've been working on that I forgot to bring with me over here this afternoon, so we may have those to file in the morning, but they are all in line with the idea of insanity provision based on some of the arguments we've previously made in the case.
Okay.
You said you're going to file amended? Okay.
Yeah, there's like 4.
Are they pattern charges or are they
No,
other things?
case law based.
Okay, well, as soon as you can get those to me and to Ms. Roper, I would appreciate that.
I'll try to email them to everybody tonight and then officially have them filed tomorrow morning.
Your Honor, the state's probably based on the testimony that came out today. Dr. Ballard kept using the term coercion in her testimony, so the state's probably going to be requesting a charge that the defense of coercion is not available for the crime of murder in the state of Georgia. Obviously that's statutory, but
We're not.
I just don't want there to be any confusion about
Coercive.
Well, what's the state say about voluntary manslaughter or involuntary manslaughter? Or, I think what's criminal negligence?
I would need to pull up their request
not,
charge.
criminal, or cruelty to children in the second.
Your Honor, I can provide the court with the case law that specifically says that an infant cannot provide the provocation necessary to justify that charge. That was one of the things that I had discussed with the defense in us communicating about potential plea negotiations. Additionally, I think there's no evidence that this was a negligent act. It is clear that it was an intentional act. Cruelty in the second or murder in the second relates to an act of negligence. There's no evidence of negligence in this case. The sole issue is whether she could form the intent or not, but if she could form the intent, it was clearly intentional and malicious, and not a negligent act. The state would object to charging on either of those things, and I'm happy to provide the authority to the court.
You don't have to provide any authority. If y'all are, the defense is moving forward with those requests, I need to hear some authority from you on that. I'm going to spend some time with the charge this evening as well. And hopefully, as soon as we get through it, the evidence, the jury may take a little bit longer lunch tomorrow because we'll have to discuss all that before closing. Anything else?
So we don't anticipate closing until after lunch then, is what I'm hearing.
Well, I don't want to mislead you. I am just kind of guesstimating based on how long the other two experts have been on the stand that Dr. Zom's testimony may take some time. Maybe not. Maybe I'm wrong about that.
Can I inquire what order she's being questioned in?
I'm sorry?
Dr. Zom, did the court make a decision about who's to question her first or whether you're going to give a preliminary instruction?
I thought I already said all this. If I didn't, the introduction or the instruction is that sometimes the law requires that an independent witness become involved in the case, or third party evaluate. I don't know the exact verbiage. We talked about it in chambers, and that I thought that was, everybody was in agreement with that.
Yes,
I also thought that it was, again, just for lack of, somebody has to go first. I didn't hear any objection to the state going first. Is there any?
No.
Okay. All right. Anything else?
Thank you.
All right. I'll see y'all tomorrow morning at 9.